Yeah, so welcome. Today's topic is estate planning, basically protecting your assets for the next generation, so that, and it is something that we're seeing a lot of. I guess it's what I understand from lawyers. It is the #1 growth area for legal practices because of the amount of disputes that are going on with estate planning, and it's very topical. We spend, as accountants and advisors, we spend a lot of time helping clients to build up their wealth, and it's this next step on how to continue to pass that on as well. So going forward, so just some important information, obviously just all the fine print that we need to cover. This is general advice, it's not personal advice to your situation, so do seek advice if you have any specific questions in relation to your personal situation. Just to introduce myself, so Shannon Smith, I think I probably know half the people on the call today, and for those that I haven't met before, welcome to today's discussion on estate planning. A bit about my background: I started up Smart Business Solutions now 16 years ago. We offer financial planning as well, and more recently mortgage broking. I was announced Financial Advisor of the Year a few years ago on a global award, and then also SMSF Advisor, which is something I actually really enjoy on the SMF side of things. Also presenting with me today is Bianca Carroll. Bianca actually started with me as an administration role. Her background was a vet surgical nurse, and you're probably thinking it's very interesting to go from one extreme to the other. Fast forward a number of years later, a master's in financial planning, that she managed to work full-time, have 2 young kids, and do a master's in financial planning, and then top the whole country on one of the subjects. So it is very fitting that Bianca took out Emerging Advisor of the Year in February this year. So Bianca will be presenting with me today. So going through the agenda, we're going to try and make estate planning sound somewhat exciting. What is estate planning? We want to go through how it impacts maybe not only yourself, maybe depending on the age of your parents, it might be something that comes up in discussions with your parents, or should come up with discussions with your parents. As I know, a lot of older people, if I think of my own parents' generation, haven't really thought strategically about the estate planning, which is really something that we want to go through today, because there are some real tax implications and asset protection implications. So we will go through that asset protection side of things. The ins and out of wills, it's not just those cheap $400 wills that you see, the little sandwich board. One of our big favourites is the Testamentary Trust, and the power that you can have with the Testamentary Trust. A bit of power from the grave, I guess you could nearly say, but really to protect your family. And then touch on blended families and how you can manage that situation, power of attorneys, and then some tax-effective estate planning. So I'm going to hand you over to Bianca to start us going through what is estate planning.
Thank you very much, Shannon, for that smart introduction. So estate planning can at times be difficult and a confusing subject to discuss. We have that mindset of, not discussing our estate planning affairs with others, with our family and friends, but, that might actually help us to make those important decisions for our estate planning. So it is very important to ensure that your assets are distributed to your loved ones according to your wishes, and that they're done in a tax-effective manner as well. So what is estate planning? So estate planning ensures that you are looked after during your lifetime according to your wishes, and that also upon your death that your assets will be managed and transferred according to your wishes in the most financially efficient and tax efficient way to the people that you wish for them to benefit. It also provides you with peace of mind, knowing that your estate planning matters are in order, because it can be a rather difficult time when a family member can no longer make their own financial or medical decisions, and it can be even more difficult when they pass away. So it can give you great peace of mind knowing that your affairs will be handled according to your wishes. It's important to discuss your estate planning decisions with your family, if you're comfortable to do so, to ensure that they understand your wishes as well. So as part of your estate planning, it's more than just your will. It's making sure whether, oops, sorry, I've just skipped that, whether your will is up to date, making sure that it is up to date. If you have had any significant changes, then making sure that your will has been changed after those significant changes, such as if you've been married, been divorced, or had children. It's also important to check that you have adequate life insurance. Do you have enough life insurance in place to take care of your debt and your family's expenses if you were to pass away? And does your life insurance have an up-to-date beneficiary as well? So your nominated beneficiary on your life insurance policy is a person or persons that you nominate to receive your life insurance benefit when you pass. The tax consequences of how your assets are distributed. So this can differ as to whether your assets are distributed to a dependent or a non-dependent. Implementing a binding death benefit nomination for your superannuation is important as well. So making sure that these death benefit nominations on your super are also up to date. So if you were to pass away, that your superannuation benefits are inherited to your nominated beneficiary. And then also looking at your enduring power of attorney. So if you are unable to make financial or medical decisions, that you have someone or a few people on your behalf to make those decisions as to your wishes. Also, if you own a business, implementing an appropriate business succession plan is something important too, because what would happen to your day-to-day running of your business if you were not able to do that yourself? So commonly, spouses will elect each other as their executors for their wills and as their enduring power of attorneys. But it's also important to have a think about a substitute executor for your wills and also a substitute enduring a power of attorney to make those medical and financial decisions on your behalf if your spouse is not around or is not able to. Asset protection, so that's very important. You've worked hard, you've built up your assets. So using smart legal strategies to protect your assets is quite important. So that includes isolating assets of value from risk, such as housing passive income producing assets in separate structures to a business structure. Segmenting multiple sources of risk so that liability or exposure from one activity does not contaminate or put at risk assets in unrelated entities. So carrying on separate businesses in separate structures. Limiting the number and the value of assets held by at-risk individuals. So transferring the legal ownership of valuable assets from at-risk individuals to lower risk entities or individuals. So a successful outcome of asset protection planning might include the ability for at-risk individuals and their families to control or benefit from assets without legally owning them. And the consequences is that the at-risk individual becomes subject to liabilities or claims from creditors, and those assets would not then be available to satisfy them, even if a creditor is successful. It is important that you have a good understanding of what we call the 5 key principles of asset protection before we make specific recommendations to you. So the first and second principles apply to all businesses, and then the third, fourth, and fifth principles start to apply as your business and your family wealth grows. So the first principle is separating risk from assets. So business risks should be kept separate from business and investment assets. And when running a business, you have risks whenever you enter into a business or into a contract with customers, suppliers, creditors, and employees. In most cases, the minimum business structure required will include a trading entity and a separate asset holding entity, and we call this a level 1 structure. The asset holding entity should never have business relationships. It should only invest or loan funds to related entities. Number 2 is choose a risk taker and an asset holder. So within a family group, you should choose one individual to be the risk taker and another individual to be the asset holder. So the risk taker should be the main person involved in your business and therefore be the director of any trading companies or trustee trading companies. And the asset holder should not be or act or seem to be acting as a director of any trading companies. So the asset holder should be in control as director, trustee, and shareholder of any asset holding entities. And where possible, the risk taker should not only own assets in their should not own any assets in their individual name. The risk taker should be an unattractive target to take legal action against. So in most cases, the family home should be owned 100% by the asset holder. If we look at point 3, separating business risks from business assets. So establish a business asset holding entity and separate your personal asset holding entity and transfer all intellectual property, trademarks, patents, logos, business names, plant and equipment to this new entity. Establish a license agreement to license the use of all IP from the business asset holding entity to the trading entity, and a service agreement to record the lease or the rent of the other business assets. We're looking at point 4, so different businesses should operate from separate entities. So to prevent the possible failure of one business venture affecting any other business ventures, different businesses or divisions within a business should operate from separate business entities. So as an example, if the water leaks in a submarine, the compartment can be locked off to prevent water getting into the other compartments and sinking the entire submarine. So in the same way, if problems develop within a business, if it fails or has legal action taken against it, it should be kept separate from other successful business divisions so that it can continue. And number 5, regularly move all surplus funds from the risk side to the asset side. So ensuring that income and retained profits in your trading entity does not remain in the entity as working capital. So that if your trading entity had legal action taken against it, then any retained profits are at risk. Instead, fully distribute the profits from your trading entity at least once each quarter to provide working capital. You could lend them back to your asset holding entity using a process known as the PPSR loan protection. So ensure that any trading entities have the minimum of assets, small amount of cash, debtors and stock only, and that no loans remain owing from individuals or related entities to the trading entity. Successor director, so this is a must for all company owners. So the problem can be if a single director company is incapacitated and cannot act as the director, or if they pass away without a properly drafted will and company resolutions, their business may not be able to operate and their staff may end up not being paid. So this could be a very disastrous effect on the business. Multi-director company, if you have an incapacitated director, or the director cannot vote on issues to protect their business and their family interests, the remaining directors could make decisions to benefit themselves and not you as one of the directors of that company. So who should be the successor director? So generally the asset holding person in a family group should be a successor director. And to create a successor director solution for your companies, we need to review the constitutions of companies. If required, arrange for updated constitutions to be prepared that specifically allow for successor directors. Prepare a resolution of directors to allow for the appointment of a successor director. So the protector, is the protector needed for the successor director? So in most family groups, one person will be the risk taker and the other will be the asset holder. And the risk taker will be the company director and the asset holder would normally be the successor director. So once the asset holder is officially appointed as a successor director, then any assets in their personal name become at risk. So it's really important to protect this. And we can do this via the protector. So the protector is an asset protection trust package. So it not only provides asset protection, but ensures that your assets are held for the benefit of those beneficiaries in your lineage or bloodline that you want to include. And this will ensure that your hard-earned assets, hard work and your assets are kept in the hands of your lineage. The protector involves the creation of a special purpose trust for your beneficiaries, including yourself and your spouse and your children if you wish. And if you have any existing trust, this may prove suitable to use for this protection trust, unless it is also potentially open to other business or services. So once the asset protection trust is established, we transfer the equity in your current assets, which can include your family home, into the trust and then lend it back to you for your use. So this means no tax or stamp duty issues, but more importantly, this means vital asset protection. And so as you can see here in this example, so on the left here, we have our assets which go into our estate, which then go to are inherited to our beneficiaries. But on the right-hand side, we have our extra layer of protection with our family protection trust. And if we have an SMSF, we can also have our SMSF death benefits trust as well. So this is a great question. What exactly is a will? So let's have a look at what can be included in a will and how it works. So a will is a legal document which contains instructions for who you want to receive your assets, who you would want to receive specific personal gifts such as heirloom items or jewelry. You can also appoint a guardian or guardians for any children that you have who are under 18 years of age. You can also appoint your executor or executors. So this could be one person or more than one person that you nominate to carry out your wishes that are explained in your will. You may choose an initial executor, so quite often spouses will choose each other as their initial executor. And then you may also choose a substitute executor or a couple of people as your substitute executor to work together to make decisions. In your will, you can also include wishes regarding your funeral, burial, cremation. You can include wishes including your organ donation. You can include wishes about your pets and who you would like to look after them. You can also include your wishes about social media and who you would like to manage your social media accounts or who you would like to close them for you, and any other important notes that you would like to include in your will as well. A testamentary trust can also be included in your will, and we will go through that in a moment. So a solicitor can help you draft a legal will, but it is also very important to work with your accountant and financial advisor to ensure that the appropriate financial structures are considered when you are drafting your wills. So if you pass away without a will or your will is no longer valid, then you are passing away or dying intestate. So in this case, your assets would be distributed according to the laws of the state or the territory in which you lived at the time of your passing. And this can cause stress and can be expensive for your family in an already difficult time. If you do have children under 18 who are left without a parent, and if you don't have a valid will, appointing a guardian for them, then a guardian would be appointed under the laws of the state or the territory in which they live. So the majority of a person's assets are governed by a will, including your possessions such as your home contents and cars, property such as your family home, investment property held in your name, money in bank accounts, offset accounts, shares and managed funds held in your name. So it's important to ensure your assets are owned in the appropriate way to minimise the stamp duty or the potential capital gains tax if these assets need to be transferred to a beneficiary. So there are assets that are not governed by a will, or also known as non-estate assets. So these can include assets owned as joint tenant. So that is when you own your home together. So if you own your home with your spouse and you pass away, then the other half of your home will automatically be inherited by your joint tenant or spouse. Non-estate assets also include assets owned by a company or held in a trust. Non-estate assets also include your superannuation death benefits and also life insurance benefits. And if you do have a self-managed superannuation fund or SMSF, then your super benefits from your SMSF would also then be passed through an SMSF will, not through your personal will. So we did mention earlier testamentary trust, and that can be included in a will. So what is a testamentary trust? So let's have a look at what it is, what can be included, and how a testamentary trust works. So testamentary trusts can be included in a will. It only comes into existence when the will maker passes. It can be useful for making tax-effective distributions to beneficiaries under 18, as they would be taxed at marginal tax rates instead of at minor tax rates. It is good for caring for children or dependents who are unable to care for themselves. It can prevent beneficiaries from spending their inheritance inappropriately or early. And then conditions can be added so that children are not able to access their testamentary trust until they reach a certain age. And conditions can be added as to what the children can spend the testamentary trust funds on, such as educational, first car or home deposit. So if we have a look at an example of a simple testamentary trust, so in this will, there is one testamentary trust and all the beneficiaries, including the spouse and children, will then inherit the estate assets from the will maker through the testamentary trust. If we have a look at another example of testamentary trust, so in this example, we actually have 3 testamentary trusts set up from the will. So in here, the will maker's estate assets will pass through into 3 testamentary trusts, so 1 for each child in this example. So a testamentary trust is designed to provide maximum flexibility and allow for tax-effective distribution of capital and income, as well as providing possible protection of your beneficiaries from third parties such as creditors. So the trusts allow for optimum allocation of income and capital, which in turn may permit beneficiaries to qualify for aged, disability and sole parent pensions, for which they may have not otherwise qualified for under a normal inheritance. So the incorporation of testamentary trust in a will is not always relevant to every situation. In most cases, it can offer valuable advantages over a simple will. So it is always best to check with your professionals that you see, such as your accountants, advisors, and solicitors. Testamentary trusts, they can be discretionary trusts, capital protected trusts, or they can be tailored to the client's requirements. And they're very similar to a family trust. So the trustee of a testamentary trust can be your surviving spouse or child or children. And if flexibility is desired, the trustee will control the gift as if they own the assets in the trust, but will enjoy the protection afforded by the trust. And as mentioned before, you can also restrict the control that your spouse or child have over the trust assets. You can use a third party as a trustee, but still retain a discretionary trust. You could add a third party as a joint trustee along with your spouse or child, but still use the discretionary trust. So regardless of who the trustee is, you can restrict access to the capital of the trust by allowing access to income or a percentage of the capital as you determine. So the testamentary trust allows the beneficiary to use, invest, change and control assets freely. Generally, the beneficiary is the trustee of their own trust, but as discussed, a third party can be appointed. And so examples of where the beneficiary is facing bankruptcy or divorce or relationship problems, then these assets are protected from those things if they're held while they're held in the testamentary trust. So generally, there are a few restrictions placed on how the trustee is to manage or maintain the assets, and the trustee can dispose of the assets as they see fit. But once the assets leave the testamentary trust, then they're no longer protected. And then, as discussed before, the The assets held in the testamentary trust are protected from family breakdown or bankruptcy as well. So when assets pass directly to one of your beneficiaries, the assets immediately become available to any person who makes a claim against them. So this includes their creditors if they're in financial difficulty, or an estranged spouse or other relatives if they're going through relationship troubles. If instead your assets pass in through testamentary trust, the assets benefit from a high level of protection from these claims. So keeping your assets within your bloodline. So this can be very important for some people. So when your asset pass directly to your spouse, it's not ordinarily possible for you to ensure from the grave that your children are provided for, particularly if your spouse remarries and has other children. So a testamentary trust can be used to give your spouse control over the annual income from the assets and possibly some capital, but at the same time provide for the assets to ultimately pass to your children as you wished. And it can also provide assets to your grandchildren as well down through the bloodline with the longevity of the testamentary trust. So at least with this way, with the testamentary trust, that'll ensure that your children will have a say in how and when they use their assets and what happens to them according to your wishes. So if we look at tax rates, so testamentary trusts are tax effective. So income that is distributed to children under 18 from the ordinary trust is subject to the minor tax rate, which is high, whereas income distributed from a testamentary trust is actually taxed at marginal tax rates. So you're paying less tax if you have income distributed from the testamentary trust in comparison. So when we're looking at capital gains tax and stamp duty flexibility, so when you pass away and an asset passes directly to one of your beneficiaries, a transfer of all or part of that asset to another person will trigger a capital gains tax event, and stamp duty for that beneficiary is likely. This is because the beneficiary has a fixed interest in the asset from the time of your death. So for example, if you have two children and each is given an equal share in two houses and they decide to take one house each, the capital gains tax will be triggered on 50% of each house. So in some states, there'll also be a stamp duty consequence. And this is because each child is transferring a half interest in each house to the other child. However, if both houses pass into the testamentary trust, each child can usually take a single house without triggering that capital gains tax or stamp duty. So this can greatly reduce the cost of restructuring entitlements under an estate. So giving assets to your children over time. So it's well recognised that giving a child significant money at an early age, not always good for them. It is ordinarily difficult to prevent a child beneficiary getting their hands on an asset when they reach 18. So a testamentary trust can provide a high level of control and certainty as to when your child can gain access to the particular assets and for what purpose as well. So it's possible with the assets held in the testamentary trust that you can stagger them over time. You can choose an age that you're comfortable with, whether it be 21, 25 or 30, that your child or children would be able to access the assets in the testamentary trust. And you can also pop on there whether you would like those assets to be used for certain instances, such as their first home deposit or education or their first car. So income flexibility. When an asset passes directly to one of your beneficiaries, that person then becomes taxable on all the income from that asset. Whereas if the asset passes to the trustee of a testamentary trust, the trustee can choose how to distribute that income from year to year. So this enables the trustee to take advantage of the lower marginal tax rates of one or more of the potential beneficiaries. So estate planning can be complicated enough. But then if you have a blended family as well, if you have children from previous relationships, this can make it even more complex. So if we have a look at mutual wills and testamentary trusts, they can be useful strategies to ensure that all of your beneficiaries are taken care of. An example of a mutual will is where each partner agrees to leave their assets to the surviving spouse, and then the survivor leaves the assets to all of the children as previously agreed, including children from previous relationships. So let's have a look at power of attorney. So power of attorney gives you choice and control over who makes decisions for you when you are no longer able to do so. And these may include decisions for finances, medical or lifestyle decisions. So a power of attorney grants the nominated person the power to legally act on your behalf, and there are 4 types of power of attorneys: specific, limited, general and enduring. So a specific attorney enables the person to act on your behalf for a specified purpose. A limited attorney enables a person to carry out a particular transaction on your behalf. General attorney enables the person to carry out any business for you or deal with your affairs and assets. And the enduring attorney will make decisions on your behalf when it comes to medical and financial decisions when you are unable to. So upon death, any power of attorney issued becomes invalid, and your will and executor would then take over the management of your affairs. In Victoria, you may also need to put in place an enduring guardian or a medical decision maker to make medical decisions on your behalf. So there are many strategies that you can use to help your estate planning be tax effective as possible for your dependents and beneficiaries. So tax effective estate planning means that smart strategies have been considered and implemented within your will to ensure that more money is left behind for your loved ones and less money is lost in taxes and fees. So on death, as discussed before, any power of attorney issued becomes invalid, and then your will and executor take over the management of your affairs. The disposal of assets in accordance with your will may have tax consequences, including capital gains tax, that you should consider when drafting your will and creating your estate plan. And there are many strategies you can use to help you make your estate plan as tax effective as possible for your dependents and beneficiaries. For example, the proceeds of an insurance policy paid from superannuation fund are tax-free if paid to dependents. Using testamentary trust can be an effective way to provide inheritance to young children. So seek advice from an accountant and financial advisor in collaboration with your solicitor to ensure that your estate planning is effective, tax effective, and also effective for you and your family and your wishes. So I'd now like to hand back to Shannon to go through estate planning protection at different stages.
So when we look at estate planning and protection, who needs to do what and when do they need to do it? Basically, when we look at it, it's everyone. Everyone should be looking at an enduring power of attorney. You should be making sure you've got a will or a will with a testamentary trust in place. When I look at wills with testamentary trusts, anyone who has children, I believe, should actually be looking at a will with a testamentary trust, no matter what age the children are. And this is where it can come to that barbecue conversation with your parents to see if they maybe have actually considered putting testamentary trusts in their wills, because when you inherit as an adult child, it would be from an asset protection, as Bianca's gone through, and potentially tax effective for distributions potentially to your children or even your children's children. Also to consider an advanced healthcare directive, and then also the enduring guardian if your children are younger. So most importantly too, just also to consider, there are other aspects as well. Property investors and homeowners, We strongly recommend looking at the asset protection using what we call the protector, which is a gift and loan back strategy. So it's really taking out a lot of the equity that you might have in investment properties. Now, you may have put the investment property for tax purposes into the high income earner's name. They may also be the business owner, and so there may be some risk should there be issues with the business. So you can actually look at this protector strategy, which enables us to very kind of, I guess, easily, a lot of paperwork, but very easily take the equity out without any capital gains or stamp duty consequences as well, just to secure it in using what we call a family protection trust. And looking at it as well, but it's especially those that are business owners. This is probably the number one thing that we'd be recommending. We are looking at upgrading a lot of our clients' discretionary trusts to what we call leading member discretionary trusts. That enables further asset protection and also succession going forward. And as Bianca mentioned earlier, successor director solutions, really to ensure sole directors or even multi-director companies have continuity if something was to happen. And we saw that even most recently. And the reason I guess the successor director has become a lot more topical with accountants is, as accountants, we get to know the family, we get to know the situations. And if there is, if one of the directors does pass away, I guess you could say years ago, accountants would just update the ASIC. Now, there's been a few court cases where the accountant just updated the ASIC. There wasn't a successor director in place, and they've got other parties that are going after the accountant for doing so. So now we did even have that recently. We did have one of our clients pass away. They had not put in place a successor director. So there was a lull of time that we couldn't do anything. And I know it took 2 seconds for us to actually update on ASIC, but we're not permitted to actually update it. So I highly recommend, if you're running a business, that you have a successor director, which means if something happens to one person, here's the second one. Also, there can be some strategies around that Div 7A as well. So it's not just about getting those wills together. It's actually, there's a lot more. Discretionary trust clients, if you do have a discretionary trust, making sure you upgrade it so that we can get further asset protection on that. Looking at how we might be able to pay out beneficiary loan accounts with a promissory note to kind of protect those as well, and then annual trust distributions using that as well. So some of it does sound a bit complex. We can go through that, but it is about trying to, you've built up all of this wealth. You want to protect it, and you also want to make sure it goes to those that that you want it to go to. As I said before, for lawyers, estate planning, this is the fastest growing area for law. Why? Because anyone can challenge the estate. Very easy for people to be successful in challenging the estate, and it's the estate that pays the legal fees. So, someone doesn't get all of what they want, very easy for them to actually start pursuing that further. If you've got a self-managed super fund, retired with a self-managed super fund, or in the accumulation, we can actually upgrade parts of the will as well. If you have adult children who are dependent on you, especially in the way in which those adult children would inherit from the self-managed super fund, you can really help save quite a bit of tax on that front as well, and upgrade the SMSF corporate trustee to a leading member corporate trustee. So we really kind of trying to button up a lot of these aspects that are really coming through in a lot of the court cases at the moment as the lawyers are going through this process. So if you do have any questions on that so far, let me just check if we've got any questions. I haven't got any questions that have come through. It's probably a lot. It's probably more than you actually expected to go through in estate planning, and a lot to cover today. But does anyone have any other questions at all? I haven't seen any come through. Now, if you do have any other specific questions, do feel free to reach out. We do say this video will be up on our YouTube. We do have a number of other videos up on our YouTube that may be useful for you to have a look at as well. So feel free to like and subscribe and see what we've got up there. Thanks very much for joining us today. Thanks, Bianca, for going through that. Made my job a lot easier. But do feel free to reach out if you do have any questions in relation to estate planning. It is something that is really important what we often find is a lot of our clients, once they've gone through a lot of this process with us, tend to be trying to, talk to their parents and making sure their parents have more current wills than potentially the wills that they may have had in place. So hope you have a great rest of your week. Thanks very much for joining us.
Thank you.